Good morning, everybody. Thank you very much for joining me. This is, as advertised, an interactive workshop. And what that means for those of you who haven't done them with me on Zoom before is that you've got some problem scenarios in advance, as I've been saying, as people are joining. If you haven't got those in front of you, you will need them. So ideally on a separate screen, so you can see this screen with me and the slides and the questions, and you can have the scenarios to one side. So if you haven't got them, take a moment now, please, to download them. As I say, ideally on a separate device. We'll be using those throughout the session. The way the session will work is those scenarios pose some problem questions. If we were in person, I'd be breaking you off into groups and asking you to talk through the answers so that you get the benefit of each other's views and experiences as well as my own. We can't do that as satisfactorily on Zoom. I think breakout rooms for a webinar is probably a bit ambitious. So instead we can use the chat function. So if you keep that open this morning, and at times I'm going to be asking you directly to contribute into it, but if you've got thoughts or ideas or views on anything I'm saying, then please use the chat function for that. If you've got particular questions that you would like me to answer at the end, I'm very happy to do that. And the Q&A function is the best place to put those. So if it's a specific question, pop it in the Q&A and I will look at those at the end. And if it's sharing thoughts or ideas or questions as we go along, pop those in the chat function. Okay, let's get started. I'm going to start by sharing my screen with you. Scenario 1. So as I say, you have had these in advance. What's on the screen is a shortened version of the scenario in your handout. So it's probably best to refer to the one in your handout, but this is a brief précis. You have got here Julie and Paul, who've been living together in a relatively long-term relationship, unmarried. They've separated and they're now in the midst of a rather nasty Talata dispute. They own a property together in Winchester, and that's the house which there's a dispute over beneficial ownership shares. They also own 2 other properties, one in Cornwall, one in Spain, which need to be sold or purchased by one or the other. 3 months ago, the parties agreed to mediate, and you obtained valuations of the UK properties, and you've got there some values and the relative mortgage figures. And you're told in the problem question that you've also given, well done you, some clear advice to Julie about her prospects of success, and that essentially there's a risk that she won't obtain a 50% beneficial interest. Julie is ready to make a compromise to bring the litigation to an end. So far, so good. So question 1, and this is the point where you might want to have your scenario to the side so you can still read that as well as the question. Are you ready to mediate? And if not, what further preparation, if any, do you need to undertake? And you've got 3 options. And in a moment, I'm going to launch a poll. And this is the way today's going to work. You're going to have the question on the screen, then a question is going to pop up in front of you so you can answer interactively. And then we will be able to effectively have a discussion about what we think the answer is. I'm not sure the extent to which I can see the chat function whilst I've got my screen share. So let me just check I can do that. Yes, I can. And then with that, I'm going to launch the first poll. So your questions are, what further preparation to mediate, if any, do you need? Do you just need a valuation of the Spanish property? So you obviously need something. Do you need further valuations of all the properties? And if you're picking answer number 2, it's not enough to just click on answer 2, please. Tell us what in the chat function. So what further valuation evidence might you need here? Or is the answer number 3, do you need more than just valuation information? And again, if you're saying you need something more, tell us what in the chat function, please. So that question should now appear in front of you. Click on the relevant answer and then please contribute in the chat, because otherwise I'm going to feel very lonely this morning. Okay, I'm going to give you 1 more second for any last answers. They seem to have stopped. And then let's see what you thought. So the vast majority of you, 72%, think you need more than just property valuations, which is absolutely right. Let's have a look in the chat function. Things about the mortgage payment, excellent. Detailed valuation about how they paid for each of them, valuation for the Spanish property, details of financial contributions made, which is all absolutely accurate. But I'm focused really today, as you hopefully wanted me to be, on mediation. So from a mediation point of view, I think there's 4 categories of extra information that you need. The first category of extra information is valuation info. So obviously you need a valuation of the Spanish property. You can't really get started in a Talata dispute without knowing what offers to make from what the various properties are valued at. But I think you do need more than that. You've got your UK valuations, but what I think you really need to know is, what does Paul say about your valuations? So in the response on the Q&A, most of the questions were internally focused within your camp, within your side. And in terms of preparing for mediation, you need to just open the peephole a little bit and think about the other side. So in terms of your UK valuations, you've got them, great, but that's not enough. Does Paul agree them? If Paul doesn't agree them, is he going to be getting his own valuations? And if he is getting his own valuations, can we please see those ahead of the mediation so you know what you're dealing with? If it were me preparing for this mediation, I might make a condition of mediating to have some sort of response from Paul on your valuations. And if he intends to get his own, to have had those disclosed to you ahead of the mediation, ideally ahead of the date on which the mediator's fee becomes incurred. Because you're not going to make progress, or real progress, in a Talata mediation if you haven't got the basic fundamental information about what properties are worth. And I think you do need to know that you're not going to be caught by surprise by what someone else is saying they're worth. And that can be one of the things that causes a mediation to unravel. So ahead of the mediation, make it a condition of mediating. What does Paul say about your valuations? And can you have copies of his if his views are different? There's obviously the possibility with a mediation of having a joint valuation. A joint valuation report is probably a lot less helpful at mediation than it is a court, because of course it's not binding at mediation. And it's perfectly possible for someone to say, well, I don't agree with that, I'll be getting some other values that will disprove that. At court, the joint report is binding. What can be helpful is agreeing valuations if you can, if the other side are that inclined. Agreeing purposes just for the purposes of evaluations, just for the purposes of mediation if possible. But I think the key message here is, it's not enough to have your own valuations. You will fast track the mediation, you will save time and potentially save it unraveling if you can either have agreed valuations for the purpose of mediating, or you can at least know in advance Paul's position, so you can explore that with your client and know if you need to get any additional or follow-up valuation evidence yourself. So that's valuations. The second category of information I think you need is cost information. It was in your problem question, although perhaps I was a bit unfair in not reading that out. You're representing Julie on a deferred fee basis. So cost information in terms of your costs up to and including the date of mediation are always important before you start. But in this case, they're really key, because if you're acting on a deferred fee, then Julie can't possibly know what she's going to have from the proceeds of sale of the Cornwall and the Spanish properties until she knows what she's paying you. She can't know what she's got to offer Paul. Third category of information is about the mortgages, and some of the answers in the Q&A tended towards thinking about mortgages. And I think there's two aspects to this. Firstly, some mortgage redemption figures for each of the two UK mortgages would be really helpful, because if this gets close to the wire of what Julie can afford, and if you've looked ahead to question 2, that might be where we're at. Actually, an early repayment charge of a few £1,000s could make a difference. And you and Julie need to know you're not going to sign her up to something she can't afford. And the other thing you really need to know on that theme is Julie's mortgaging capacity if she can't buy Paul out in cash. So the first question is, can Julie, once Spain and Cornwall are sold, pay cash to buy Paul out of Winchester? We saw the mortgage existing on it in the previous slide, and we know it's a £1.3 million home, so possibly not. She's on a deferred fee, it tells you in the problem question, because she's got some cash flow issues. So can Julie buy Paul out cash? And if she can't, what's her borrowing capacity? And what ideally you would like is an offer in principle from a broker or a bank, but you at least need to have had that conversation, not just with Julie, but she needs some sort of indication about her borrowing capacity. And again, this is the sort of thing that if you haven't done that in advance, it can unravel a mediation, or it can mean that what you get at mediation is an agreement that's conditional. So provided Julie can get the mortgage she thinks she can get, this is the deal you'll be doing, which is obviously a lot less satisfactory for everyone than having the confidence that you know you can agree to that there and then. Fourth category of information is a really common pitfall. And it's not obvious to think about, but it's something that is rarely done. And that's chattels. You've got 3 houses here that they've lived together in for a number of years. There are things in those houses. What does Julie want? Is there anything in those homes of particular value? These are relatively well-off people. There might be something of particular value. Is there anything of particular significance to Julie? Is there something of emotional significance or of sentimental value? And if the answer to those things is yes, something's important to her because she doesn't necessarily want it, but it's really valuable and needs to be paid for it. Or absolutely, she has to have that painting that's been handed down from generations in her family, then that might need to form part of an early offer, even an early offer. It's certainly going to need to be mentioned to the mediator that there are specific chattels that are going to potentially cause difficulties further down the road. And this is so often overlooked. And it's overlooked because it doesn't form part of the litigation. This wouldn't be in the pleadings. This is not something that the judge is, within the scope of this case, probably going to make any decision about. And yet, time and time again, these are the things that cause real problems in terms of either preventing a settlement or causing a mediation to go late into the night and last a lot longer than it needs to last. So from my point of view, a key to good mediation preparation is trying to think outside of the litigation issues. You obviously need to think about those, but add to your checklist, if you've got one, for preparing for mediation, chattels, but also dates. It's a similar theme. Sometimes it's very important to somebody when something is done by. So in a lot of my cases, I do mostly estates work. It's often very important to somebody that he's out of the house by the anniversary of Dad's death. Or I've had other cases where somebody's getting married, and it's actually really important to the parties that the litigation is wrapped up before the marriage. Potentially someone needs money for something in particular, and therefore the date of a payment can be particularly important. And again, knowing these things in advance, having had that conversation with your client, can really speed up a mediation and can allow a mediator to negotiate these potential stumbling blocks in a much more timely way. We're now going to move to question 2. So we're sticking with the same scenario. We've still got Julie and Paul and the Chalata dispute, but it's now the day of the mediation. I'm going to give you just a second to read question 2, give you a break from my voice. Again, what's on the screen, I think this time, is what's in your handout, so you can just read the screen, and then I'll give you a brief summary and we'll discuss the question. Okay, so it's the day of the mediation. You've agreed your valuations, well done. You've got an indication from Julie that she can obtain a mortgage up to £570,000. Don't worry particularly about the numbers here, but you are told that Julie feels, even though she could get a mortgage up to that limit, she feels that she couldn't actually afford to borrow more than £450,000. And you've got some information. If Julie borrows the £450,000 she can feel she can afford to, then she can keep Winchester if she had a beneficial interest. If her interest drops to 33%, she's going to need to borrow more than she feels comfortable with borrowing. And if she obtains less than 33%, Winchester has to be sold, which is what she wants to avoid at all costs. This is the important bit. You're in a pre-mediation conference with Julie, and she tells you that her mum has offered to help her by lending her interest-free up to £200,000 from a PI claim payout that mum received last year. Now, Paul is unlikely to know certainly about the award, but certainly wouldn't realise the amount of money that Julie's mum received. And what that sum does is it would allow Julie to keep Winchester property by sticking to her self-imposed borrowing cap, but making offers or accepting offers in respect of her beneficial going down as far as 39%. So the key is, as I say, don't worry too much about the numbers. What you've got here is, in effect, a bracket of offers that Julie can make between 50%, her best case scenario, going down to 39%. And that's the bracket in which Julie can make offers or accept offers. So the key to the question is Julie going to tell you, going to advise Julie to tell the mediator about the pot of money available from her mum? And your options are, yes, you're just going to tell the mediator from the outset, let's share it. No, you're not going to do it at all. That's option 3. Or option 2 is in the middle. You will tell the mediator before she makes the offer of 39%, which is effectively the final offer that she can make. So I'm going to launch that poll. Hopefully you should see that pop up on your screen. So you've got 3 choices. Yes, you're going to tell the mediator everything, be really open. No, you're not telling the mediator that at all. Or yes, at some point you'll tell the mediator before Julie makes the offer, which will be her final offer. I haven't specifically said it, but if you want to tell us why in the chat function, which is hopefully working, and if not in the Q&A, you can do that now. Okay, and let's see what you say. So we've got a bit of a split. The majority of people, almost 60% of you, are going to tell the mediator, but are not necessarily going to do that from the outset. You're going to tell the mediator, probably make a judgment call, but make sure you do it before the final offer. I think that, as I say, the numbers here don't matter. The key here is that there are two factors that prevent Julie from compromising beyond a certain point. One of those is likely to be known, that's her borrowing capacity. And even if Paul doesn't know the exact level, they've been together for a long time, he'll know a lot about her finances. He may well have a good guess at what her borrowing capacity might be. And then the other is the money from mum. And that won't be known to Paul. And obviously, if Paul finds out that there's a pot of cash, probably without knowing what size of pot of cash it is, that potentially weakens Julie's negotiating position, or that might be your concern. So that's the dilemma here. My general view with mediations, taking a step back from this specific scenario for a moment, is that it's always a good idea to share as much as possible with the mediator. And as a mediator, it might not surprise you that I'm saying that. Tell me as much as you can. But the reason for that is the mediator is the only person that's got eyes and ears in both rooms. And obviously a mediator can't tell you what's been said in the other room unless they've been given specific permission to do that. But a mediator can use what they've seen or heard in another room to help effectively guide you. So a mediator can say, and I do say at some points, could I please have permission to repeat that last little bit that you said, or to tell them X, Y, or Z, because I think that would really help move things forward in the other room. Or because actually that will stop them going round and round in circles and bring to end a discussion or an issue that's happening in there. So sometimes it's helpful for a mediator to ask your permission to share something. A mediator can also guide you in terms of the structures of offers that you're thinking about potentially making. So if I know that an offer structured in a particular way is just not going to make any headway in another room, isn't going to meet the needs in there, or isn't aligned with the sorts of things they're talking about, I can say to you, perhaps think about structuring your offer in a different way. And I can give you guidance as to how best to do that, to make progress and to use the time most effectively. So the more a mediator knows about your thought process, the better they are able to help the parties communicate with one another. Even if that's not a direct communication, you're not actually hearing what it is that's specifically been said. Obviously, what you need to do if you're sharing with a mediator is use your mediator confidentiality. So as I said, a mediator cannot tell the other room anything that they've not been given permission to do. So if you're sharing with a mediator, what you need to be really clear about is what they can and cannot say to the other room. And obviously the mediator's bound by that. As a mediator, I'm not going to compromise my professional reputation or my professional ethics by repeating something that I've not been given permission to. And the clearer you are about it, the more the mediator is going to make absolute sure that that information isn't communicated. So in this case, I think it's really easy for a mediator to know, I'm not going to say anything about mum or a PI payment or where the money's coming from, but there's no reason why you can't share with the mediator. And in this case, you probably would never want Paul to know that some of the money was coming from that source, and that's absolutely fine. So when you're dealing with an example in this, like the one in this specific scenario, I think there's an even better reason, or a good reason, why the mediator should be told. And it boils down to this: a mediator's job is to go backwards and forwards between the rooms and push and chip away as much as possible to get improved offers to try to bring the parties together. If you have in your room a major practical block, which means you cannot offer more than or cannot accept less than a certain figure, I think the mediator needs to know that. And I'm talking about a proper practical block, not just your client doesn't want to go beyond a certain figure, or that was decided before you attended this morning that the red line was going to be X or Y, but a genuine practical block like a borrowing capacity or like a finite pot of money. I think a mediator certainly needs to know that before you make, and this is option 2, your best offer. Because otherwise a mediator is going to expect that they can put that offer to the other side, come back with Paul's counter offer, and expect to be able to continue to push you and chip away at your offer. And it will come as an unpleasant surprise to the mediator and to everybody if that's not the case. So certainly I think option 2 needs to be affected. But in my view, I would go with option 1. And the reason is that as a mediator, there is a limit to how much pushing you can do. So it is your job to go room to room and push. But in my experience, you only really get 1, depending on the mediation, possibly 2, opportunities to have a really big, challenging, difficult session with a party. If you do that too often, you lose the room, you undermine your position, ruin relationships, and you end up with that client thinking she's on the other person's side. So as a mediator, your job, my job, is to gauge when best to place that really tough session. So there might be a bit of challenging in all the sessions, but there's probably going to be one really big one where actually I upset some people and I say some things that don't go down well. And as a mediator, my job is to gauge when best to place that session. If I know that once you get close to 39%, that's it, I've got the tools to work out where to best place that session. It would be awful if I had judged that with a particular client that should come later in the day, and then I come back to you thinking, okay, my next session or the one after this is going to be the big one, and you say, oh, I'm sorry, we're at the end of the line. And you could tell me just before, which commits me to, okay, this is going to be the big challenging session because there are no more sessions. But the earlier in the day you tell me, the better able I am to work out, because I'm the person in that other room seeing what's going on, getting over sometimes emotional issues first thing in the morning or whatever, when that session is going to be most productive. So for me, I would choose option 1. And actually, if I were representing Julie, I would be really clear with the mediator that you're going to be wanting to make an opening offer of, if not a 50% beneficial interest, something close to that, to show some sort of compromise, and that you can go as far as 39. And really then you can hand that to the mediator and make it the mediator's job and the mediator's problem. The mediator knows that she or he has got to get Paul as close to 39% as possible before Julie makes her 39% offer, because that's the best prospects of settling that case then. And actually, there's a sort of element of unburdening in doing that. Since I qualified as a mediator, a good friend of mine, a colleague, has adopted that approach. And in a recent mediation, she said it made all the difference in terms of the feeling in her room and in terms of productivity. It did settle. It settled much earlier than any mediation she'd done before. And it was a weight off the shoulders, really, of the advisors in that room, because they passed some of that responsibility onto the mediator. And that's fine, because that's the mediator's job. Okay, we're going to move now on to scenario 2. I'm just going to check. I can't see anything in the chat functions. I'm just checking in the Q&A that no one's trying to talk to me. I don't think you are. Scenario 2 is, again, the version on your slide is a shortened version. So you've got the full scenario in your handout. I'm going to give you a second to read some of it to refresh your memory, and then I'll take you through the main important parts. Okay, so you're instructed in a professional negligence claim. The claim's being brought against Mr. Timms, who is your lay client, who received instructions to draft a will for Mary. Mr. Timms attended Mary at home. She'd been given 6 weeks to live, and he takes instructions, but he's got some concerns about capacity and about potential undue influence with a sister that's loitering around. He goes back to the office, effectively drops the ball and forgets about the case. And he does get a doctor out to do a capacity assessment following the golden rule. But unfortunately, by the time the doctor actually attends, Mary has passed away. It's within the 6 weeks that she was given to live, which I'm sure Mr. Timms will want to tell you lots about that, but nonetheless, there was a delay. And a claim's now being brought by the sisters, who would each have received legacies of £100,000. And there's a professional indemnity insurer who's not just floating about, but attending the mediation with you. The letter of claim, your letter of claim, has defended the case, but you've had some advice from counsel, which says in terms of liability, there's bit of a difficulty here, but you have defended it on the basis that it's not clear what the capacity assessment might have said, and there's also the possible undue influence. So it's certainly possible here that Mary may never have been able to execute a valid will in the terms that would have given the sisters £100,000 each. Mr. Timms is very difficult, your client. He refuses to accept that he's done anything particularly wrong. He wants a very robust stance and a very robust position statement with lots of emphasis on the nasty undue influence point.
So, simple question: should you ask counsel to make the position statement as aggressive as possible? Again, I'm going to pop up the poll. It's a yes or no answer, but if you want to tell me in the chat function, or if you can't make that work in the Q&A, then please do so. Okay, I'm going to bring that to an end and share the results with you. So very clear divide. 80% of you think, no, you should not be telling counsel to make your position statement as aggressive as possible. And that is music to my ears, both as counsel and a mediator, I have to say. There's two things I want to say about this. It's probably not unsurprising that as a mediator, I would say to you, don't make your position statement so aggressive, please. But it's probably more interesting to explore why. And generally my view on position statements is that aggressive position statements are not very effective. Aggression just tends to inflame the situation, make people angry, and I don't think it's helpful at all. The point of mediation is getting everybody to move together. So for my part, I think a mediation position statement should look really different from a position statement or a skeleton argument you might produce for court, which is of course going to be aggressive and make your best points. But the position statement, I think, needs to be a completely different tone. I suspect the reason people put in aggressive position statements is they think it's going to scare the other side. But in my experience of mediating, both as counsel and as a mediator, I've never seen that work. Usually, by the time you get to mediation, your client's case will have been set out at length and as robustly as possible, if not in a pleading, then certainly in correspondence. So generally, there's nothing in an aggressive position statement that's of any surprise at all. So it doesn't scare people. I actually think that what an aggressive position statement does, universally in every single case I've seen, is leave the recipient of the position statement thinking, well, that person on the other side is completely unreasonable. That party are not going to compromise, and there's absolutely no point it's being here. This is just a waste of time. And it does waste time if, as a mediator, the first thing you have to do in the morning is calm everybody back down and get them to a point where they, having agreed to mediation and started to adjust a mindset to want to compromise, have been riled back up again and are thinking this is just a pointless waste of time. So what should go into a position statement? Well, if you can, and perhaps you can't here, but generally if you can, try to use a position statement to be more practical. So focus on the practicalities of settlement. Are you looking in a family case or in a talata case, for example, for some sort of complete clean break? Are there things about the practicalities of settlement, as in the first scenario, who's buying whom out of which property, who wants to retain what, numbers in terms of mortgage redemption figures if those haven't been shared, practicalities of settlement if at all possible. You can also write a note to a mediator to have two position statements, one that you exchange with the other side and one that you just send to the mediator, or do a separate document if you're worried about getting them mixed up, where you share something with a mediator in advance of the mediation that you're not sharing with the other side. And that can be really effective. So you might let a mediator know, in this case, your client's had some advice about liability and just wants to focus on quantum for the mediation. That's really helpful and will fast track mediation. You might, going back to scenario one, use that as an opportunity to tell the mediator there's a pot of money that Paul doesn't know about, or there's a finite borrowing capacity. And these things communicated in advance can just help a mediator speed up the process. The second thing that comes out of this question on aggressive position statements is really managing your client ahead of a mediation. So obviously you need to emphasize that the final choice rests with your client. In this case, it's complicated because you've got your lay solicitor client and you've got your insurer client, and who's paying is the insurer. So there's obviously a different dynamic there. But it's really helpful to tell a client in advance, when they don't have the pressure of the mediation day, why it is your approach to mediation might be different to theirs, or why you're going to be suggesting things which feel alien to them, because mediation is about conciliation, is about compromise. So if you've got a client who wants a more aggressive position statement, that's an excellent opportunity to just take time to talk to that client in ideally a conference, and as I say, as well ahead of the mediation as possible, to give them time to think about what you're saying and allow that to sink in and potentially adjust their own mindset well ahead of the mediation day. That's relevant not just to the position statement, but also to, again, how well you can use your time on mediation and try to avoid having mediations that either don't finish or finish late in the night. So you want to be giving
advice about the case, but also advice about mediation, about the practicalities of mediation, and about what works from your experience. And that will possibly be, with some clients, dialing down some of the aggression and not being quite as forceful. Question 2. You're still with Mr. Timms and you're now at the mediation. There's not a huge amount of additional information, but you're basically at the point of opening offers, and you've obviously not yet done a very good job of managing Mr. Timms, because he's keen to make an opening offer as a just drop hands and walk away. And given the advice from counsel, everybody knows this is very far from a realistic settlement. But he wants to start low because you only end up being pushed up higher. And we'll have all heard that before. He also wants the mediator to focus with the claimants on the potential embarrassment for them of public, i.e. open court, allegations of undue influence. So he doesn't just want to make this offer that's pretty unrealistic. He wants to send it with a message. And that message is all about, again, trying to scare the claimants into submission. So again, it's a yes/no question. Should you make this opening offer? In terms of answering the question, I'm not so interested in the ethics, because obviously you've got here the insurer and the lay client. So don't worry about the ethics. Let's assume, for the purposes of answering the question, that Mr. Timms is ultimately going to go along with what the claims handler says. But it's more about whether you think this opening offer is a good idea, whether an opening offer like this, pretty aggressive and unrealistic, perhaps with quite an aggressive message, or with a message that's got a bit of an undertone, is that the sort of thing you would do in a mediation or not? Okay, let's see what people have been saying. Again, good, 85% of you wouldn't make this opening offer, but 15% would. And I think the key here is that there is obviously no complete right or wrong with mediation. It is about style. But the reason I wanted to pose this question for you, just take that poll off your screen, is because I want to say something about the psychology of offers. An opening offer sends a message, and you'll often be focused on what you want the other side to think in response to receiving that offer, receiving that message. And here the suggestion from Mr. Timms is, and presumably the 15% of you that said that you may well make that kind of aggressive offer, is wanting to scare them. And I talked about that a moment ago with position statements, but also send a message. And sometimes this is felt to be an important message, that this is not a big cash giveaway today. We're not going to be offering you big sums of money. And that is not wrong. As I say, there isn't a right answer here. I can well understand why a client and a representative would want to send that message of manage your expectations, because we're not giving away big sums of money today. What I encourage you to also think about and get your clients to think about is what you want the other side to do. So in making that sort of offer, you're focusing on what you want the other side to think or to understand. But a first offer also sends a message in terms of what you want the other side to do in response to that. Movement encourages movement. You can always send a better offer with a message, and I do this a lot when I'm counsel at mediations, of we weren't necessarily planning to make this offer first thing, or this actually was the offer we would probably have made at 4 o'clock today, but we're just going to cut to the chase and save some time. And then you allow your client an opportunity to make a big movement and then make small moves thereafter. You don't have to, just because you've made a big one, continue to make big moves. But you can, early in the day, make a big movement, send it with a message of good faith and compromise. And let's be real about where we're going to end up, the ballpark we're going to end up in today. Should we just get there and talk about what people are really willing to do? And that will save a lot of time. But it also sends a message of, we are here making genuine compromise, and therefore we expect you to make genuine compromise. And that enables a mediator to put significant pressure on the other side to make a big movement, because you've said you're here in good faith. So what why else are we here? What are we doing? If you open with an offer that's either a tiny amount of movement or no movement from your starting position, it takes a long time to get the cogs turning, and it can make it very, very difficult to start to make progress. And ultimately, your client probably pays for that at the end of the day, when the mediator's hourly rate and all the lawyers' hourly rates start to kick in. And it means that you're doing your real negotiating when everybody's already tired and drained. And I think that's probably not very fair on clients, but it's also very difficult as lawyers when we're there, it's then expected in the evening to be drafting up some sort of complicated settlement contract. It's also important to remember this idea of a first offer being a message, both in terms of a psychological message and a call to action, if you like, when you're receiving a first offer. So it can be helpful to prepare your client for that. And I think that can really help to take the heat out of receipt of an unfavourable first offer if you remind your client that this first offer is just going to be a message. Nobody's actually suggesting that they realistically expect you to pay X or accept Y. And again, that can cut out some of the inflamed situation when you receive an offer and the hours sometimes you can waste with the client just venting their anger of the lunacy of the offer that's being made if this is actually an exercise in compromise. So that can help. Another key thing about the psychology of offers is to think about whether the offer is based upon something palatable. So when you're giving or asking the mediator to pass on a rationale behind an offer, this represents this and this represents that, or pass on some sort of message, this is why we've only offered you this, then sometimes it can help to focus on the thing that's more palatable in the other room, which will often be quantum rather than liability, even if that's not your best argument at court. And here's the bit that's counterintuitive, because your best arguments at mediation are often not your best arguments at court. Your best arguments at mediation are the ones that will gain traction and encourage some sort of recognition or compromise or movement in the other room. And as I say, that's not necessarily your best argument at court. So the undue influence argument here is really key. You may have a really strong grounds for saying there was real reason court judge to think that there was undue influence going on here. And that may well really impact the loss of a chance argument or rationale in this case and bring the award down a lot. But the undue influence argument is not going to gain you traction at this mediation. Those two ladies in the other room are not going to take well to a day of being told that one of them undue influenced her sister, and that's what this court case is all about, and that's why they should compromise. So in this case, it might be better to focus on the capacity argument, which is nobody's fault, which is easier. It's harder to get them over emotive about. I'm sure they still will, but that's easier to swallow. That actually there was a professional thought there was a significant risk in terms of capacity and whether Mary could make a will. There would have been an assessment by an independent person, and nobody knows what that would have said. Now, that may well gain more traction, and it may well be more likely to result in compromise of, okay, we have to accept we don't know what that would have said, than focusing on the undue influence argument. And again, this goes back to what I was saying before about having discussions with your client ahead of the mediation to try to get them to think differently about how to approach it and about how to frame offers that will move the process in the right direction. So here the key would have been having a really good chat with Mr. Timms about why you're not necessarily think it's sensible to be as aggressive as he would have, and why you think focusing on numbers and money or focusing on capacity will actually be more effective for mediation purposes than focusing on undue influence, which doesn't at all compromise your ability, if this doesn't settle and you go to trial, to run the undue influence argument as hard as you want to. One final thing on this scenario, and it's not part of any of your questions, and it may not have popped out to you certainly when I read it to you, is that in this case, the instructions for the new will gave £100,000 legacies to each of the sisters and left residue to charities. And you do need to think about, when you're preparing for mediation, the role of others. So in this case, it's a charity. In another case, there might be some other party. And in this case, they're not currently engaged in the dispute. So this is a claim being brought by the sisters, a professional negligence claim. But there's the possibility, obviously, in the background that those charities could also have a claim. They're not currently making one, and you might decide not to be troubled by them. But the insurer might need to have some contingency set aside to deal with them if they claim. You certainly don't need them in this scenario at the mediation to settle it, but you might want, in this case or in a different case, to have them involved in some way so that you tie up all the loose ends. I don't think the answer to that matters for today's purpose, but you just need to think about it in advance and have a strategy for how it is you're going to deal with anyone that comes into that category of others. Because again, you don't want to remember halfway through the day that they exist and that that's a potential problem. So it's all about doing as much preparation as you can, thinking outside of the box in advance of the mediation, and having discussions with your clients in advance of the mediation so that your time on the day is used as effectively as possible, and then hopefully avoid those late nights. That brings us to the end of my prepared content. So if anybody's got any questions, I'm very, very happy to answer them. As I say, you can put those in the Q&A. That might be a question about something that we have discussed today, or it might be a general mediation question. I'm happy to have Basha answering any of them. If you don't have any questions, we're finished slightly ahead of schedule, 45 minutes in, you're very welcome to leave. Thank you very much for coming. There will be some feedback forms sent out following the event, and I would be really grateful if you would fill those in, just to help me in terms of preparing future seminars. And also there's an opportunity for you to write on there if there's any topics you would particularly like a seminar on, and I'm also keen to hear about those. So thank you very much for attending. I've got a question here. Any suggestions for dealing with an aggressive other side? It's really difficult because you can't control what's going on in that room. And mediation, it takes two to tango. It's a two-way process. I think the more you manage in advance, the better. So if you can be pushing to get agreed valuations or get disclosure of things that you know are going to be problematic, that can help a bit, because you can sometimes scope out if someone refuses to give you a document ahead of a mediation. Actually, is there any point going ahead? I'm the biggest advocate of mediation in the world, but I think that there are cases where you can see in advance they're just not willing, and that's just not going to work. In terms of practical things on the day, as I say, share as much with the mediator as possible to allow the mediator to have as much ammunition as possible in that room. And actually, as counterintuitive as it may seem, make that big move. Even if they're being super aggressive, if you make your big move, you allow the mediator to really push with them. Well, it's their turn now. And you can then make small movements after that, or hold at that and say, until you make us a sensible offer in a similar tone, we're not making any more offers. But before you become aggressive in response, make your big show of compromise. And that can help. It can help a mediator, as I say, to have pressure, but it can also help you to assess whether you're going to make progress, and ask the mediator, we've made this big compromise. Do you think it's worth carrying on? And then the other thing, of course, as I've said, is there something in particular that's making them aggressive? Is there something that's winding them up? In this case, the undue influence allegation might be it. There's all sorts of reasons that you won't always see. And you can ask a mediator. They might not be able to tell you, but they might ask permission to tell you if there's a big stumbling block that's causing a lot of aggression or anger in another room. Or they might just help to guide you. So is it the way we're framing our offer that's getting this response? Is there something we could do differently? And the mediator will try and help you as best they can. How often are these seminars run? Well, when I get some time to. Thank you very much for attending today. I've been running them periodically. This is probably the third or fourth I've done through lockdown, so probably a couple a year. This is the first one I've done just me. I normally have been doing them with Yasmin Uzeri and Chambers in terms of this workshop format. And I'm sure there will be more. So as I say, fill in your feedback forms and let me know if there's particular topics that would be helpful. Would you say that resolving conflict in mediation is mostly psychological or more on points of law in general? Because it will vary from case to case, and it will. But I actually think it's pretty rare for mediations to be about law, because generally the people who are driving mediation, certainly in my cases, are individuals. Even if that's a company director and this is a commercial dispute, there's still an individual who's ultimately making the decision. And I think if you can get past the emotional block that's in between that person and settlement, that can go a long way. Sometimes that's the law, and often as a mediator I find that I have to have a detailed discussion with the legal representative on a point of law, to allow their client to then get past that, to allow the advice to change. But as I say, I think very often it's about understanding the psychology. You obviously are not going to win a mediation on psychology alone. If your case is poor, your case is poor, and everybody will be able to see that. But I think in addition to preparing your legal case, which is ultimately all you prepare for court, it's worth thinking about these additional kind of psychological but also emotional aspects to mediation. For or against an opening joint session, I think that really depends on the cases. And I think for the work that I do, which is mostly estates work or to larger cases, I guess, contentious trust work, it's very often what I call pseudo family work. So there's families involved, there's people that have known each other for a long time, and very often seeing each other can inflame and make things worse. So I would normally start from the backwards assumption that in the sort of work I do, probably a joint session isn't going to help. I think if you've got more professional parties, if you were, say it wasn't, even in the second scenario, you've got a professional indemnity insurer on one side, and perhaps it's not lay individuals, but you've got some sort of commercial contract that's gone wrong, construction contract that's gone wrong, then they can be useful. The other time as a barrister I've really usefully used a joint session is when I've got something nice to say. So I don't think a joint session where people just aggressively set out, this is my effectively particulars of claim, this is my defence, and this is why we think we're right. I'm not sure that's productive. But I have had a case where as counsel, what I heard from my clients who were siblings, and it was a claim against a will, and there was a step parent on the other side, was we used to have such a nice relationship with this man, and he used to be our family, and we know that we all loved mum, and it's such a shame that this has happened. And I used that joint session to communicate that, which just took the wind out of the sails of the other side. So their barrister, that they were the claimants claiming against the estate, they went first and they gave very aggressive. And when it was my turn to talk, I didn't talk about the case at all. I said, I'm not here to talk about the merits of the case. I just want to pass on from, Bob, Jean and Joan, that this is how they're feeling, and that there was a point where they loved you very much and they're very grateful for the involvement you had in their life, and they feel really sad about the relationships that have broken down and that we are where we are. And they know that everybody who's here today is united by love for this lady. And the other side didn't know what to do with that. But what very, very quickly happened was the aggression just completely collapsed and imploded, and we made really, really swift progress. So I think joint sessions can be really useful, but in the right case and used in the right way. I don't think a joint session where you just go in and read out your position statement is really of any use to anybody. I think, as I say, you're then back in the category of when everybody peels off and the mediator goes into the room, my job's going to have to be much harder because it might take me an hour to calm down everybody from what they've heard about the aggression. A mediator taking a too legalistic approach to points of law. Difficult. Do your homework about mediators in advance. Speak to people that have had a mediation with that person. If someone's suggesting a mediator you don't know, try and find out a bit about them. Sometimes, as I say, sometimes a bit of law is important. If someone really needs to understand, or there's a big difference on a legal issue between parties, you need to understand what the other side's case is, or you need to get to a point of recognizing you're never going to agree on what the legal answer is here. Sometimes you have to park an issue for mediation, but that's possibly the answer, is saying to that mediator who's insisting on going through your case with a fine-tooth comb and a professional textbook, is saying, look, this is my view, and this is the advice I've given my client. And actually, you're not going to persuade me otherwise today. I don't want to waste time with us arguing about the law. So instead, why don't we move away from thinking about liability and talk about quantum? Or why don't we assume that this is the bracket and talk about what people are prepared to pay today? Why don't we park who's going to win and lose, and understand that people come to mediation for all sorts of reasons. There is a benefit to be gained by both parties in compromising, and understand what that's worth to each side. But it may be that a good mediator is engaging with you on a legal issue because they're testing you, or it may be that the other side can't get past a certain point and they need to hear in a bit more detail why you're convinced, and then the mediator can say, look, I've made this point, this is the response I've gotten, I know you're not going to agree with that, but if we want to make progress today, we need to find a way of moving past the disagreement. Qualifications to become a mediator, yes. I mean, I'm not sure quite how regulated it is, but most mediators are affiliated to a professional body. I'm registered with the CMC, the Civil Mediation Council. There are various out there, and those professional bodies, in order to be registered, will require qualifications. So there's a course to do, and you don't have to be a barrister or a solicitor to be a mediator. But to mediate legal cases, most people are going to want somebody who's got the legal expertise. So I have 12, 13 years of litigating estates cases, as well as the additional mediation qualification. And I think that both of those points are obviously very important. We're coming to 10:30. Unless anyone's got any last burning questions, I'm going to thank you all very much for coming, ask you again to fill in the feedback forms, and no doubt see and work with you hopefully in the future. Thank you all very much indeed.